Witnesses, at first glance, they seem so sure of what they're saying, and then I hear these kinds of statements presented by the defense where they're not entirely sure of what they're saying. They might have been fed information. They might have had their memory supplanted by articles that they read. There might have been biases. A lot of these witnesses, you just feel, I don't want to say have a dog in a fight, but they've already come up to an opinion in this case from a long time ago.
And it's preconceived from an array of different places. I mean, from a possible documentary, from a video, a movie, from all the investigation and all the press that that this case has received. And to stand here today and to say that your memory is better today than it was 20 years ago when you gave a statement about something that happened maybe multiple years prior. It's just difficult to be able to take in. Now, something you have to keep in mind is that this witness, Harmon, her large portions of her testimony is made available and possible because of the California Evidentiary Code, allowing her to attest as to what Susan had to say and how she had to say it, due to the fact that she's not here because the defendant possibly made her unavailable.
Let's talk about that. It's this thing called forfeiture by wrongdoing. I know there's been a lot of talk about why can we hear these statements, these alleged statements from Susan Berman, isn't it hearsay? Forfeiture by wrongdoing, I'm confused because it's basically saying you have a victim, a murder victim, but because the defendant killed her, those statements can come in, yet allegedly killed her. It hasn't been proven that Susan Berman was murdered by Robert Durst. So how is that allowed in? I know this has been litigated a lot between the parties.
Yeah, it walks over the Fifth Amendment a little bit, right? Because you're here saying, you're pointing the finger saying the defendant made her unavailable because he killed her, right? The defendant's saying, well, I have a Fifth Amendment right. I didn't make her unavailable. I didn't kill her. But you have to remember something. When it comes to these evidentiary issues, the judges have a lot of discretion. And when we're talking about what's more prejudicial and what's not, all that this judge has to find, all that this court has to find, is that this is less prejudice to the defendant than probative of the facts. And so if he could, if the court could find that, then it's in. So yeah, it is a little backwards, Jesse. It does feel a little not right, especially in a criminal proceeding when we're talking about the defendant and the seminal victim. In this case, she's unavailable because allegedly she was killed. So it's definitely, kind of confusing, and it crosses over a lot of different principles in evidentiary issues and in overall procedure. So it's certainly, it's something to discuss here.
Well, I'll tell you what I want to discuss, and I actually asked my producer to get this. A couple of days ago, we heard the testimony of Douglas Oliver, and this is something to listen to. This is something to watch. We're going to take a break. If you haven't seen this, oh boy,